The commercial court was filled to capacity for the much-anticipated court battle between property mogul Sudhir Ruparelia and Bank of Uganda here in Kampala. The pre-trial session was set to hear an application that had risen from the original suit lodged by Bank of Uganda and Crane Bank against Sudhir Ruparelia. Sudhir's legal team, led by Peter Kabatsi of Kampala Associated Advocates, in the application accuse BOU lawyers, MMAKS advocates and AF Mpanga advocates of conflict of interest and faults Bank of Uganda for breach of confidential settlement and release agreement.
In fact, an advocate is prohibited from representing a party litigating against his or her former client on a subject matter the former client has ever instructed counsel in question.
The law firm adds that they have since fulfilled the requirements and have listed BOU lawyers Timothy Masembe and David Mpanga in their written statements of defense as they would be witnesses and therefore must excuse themselves in this case.
It's therefore our humble prayer that this application be allowed and this court finds that indeed the first and second applicants are witnesses who have been listed and they will be needed for purposes of this court.
Sudhir's legal team argues that their client has already expressed fear that he may not have substantive justice because Masembe and Mpanga have been his lawyers for 12 years and are privy to confidential information which might prejudice his defense before court.
This suit is about the management and control of Crane Bank. Any advocate who acted for Crane Bank for 12 years cannot appear at the bar because he knows a lot more about Crane Bank than PwC ever could.
In response, both Masembe and Mpanga agreed to having represented Crane Bank in several transactions but denied ever dealing with Sudhir in his individual capacity.
You must then show that that firm of advocates, in acting for you in a specific former matter, came across information in relation to the current matter, which is prejudicial.
The listing of myself and Mr. Masembe Kanyerezi is mischievous, my lord, at best, malicious at worst.
The two asked the judge to maintain them as Crane Bank lawyers, saying there is no evidence adduced by Sudhir to show they have in any way breached their professional code of conduct, having not even come across any information regarding the current case in which Bank of Uganda accuses Sudhir of fraudulently siphoning at least $100 million or an estimated 400 billion shillings from his now defunct Crane Bank.
My lord, there is a bar against MMAKS, who are the lawyers of Crane, being called as witnesses of Mr. Ruparelia.
And my lord, it must also, in my humble submission, be taken into account that Uganda's is a fused profession. We do not have barristers separate from solicitors, so that the person who comes to you initially for purposes of getting a court matter filed is a person who may have engaged in making the demand, the initial negotiations, etc., and is separate from the person who pursues the case.
However, other parties to the case, including businessman Amos Nzei, a major shareholder of the now-defunct National Bank of Commerce, welcomed Justice Wangutusi's advice for parties to embrace mediation.
But I want to thank the Commercial Court because my colleagues went to Constitutional Court. The case has been there for the last 6 years. For the last 5.5 years, it has not been heard. But I'm so happy having from private sector to see that the Commercial Court, at least at the long list, it has come to hear our case.
The judge set November 14th as the date he will deliver his ruling on the application.